discovered having drowned in the swimming pool. That the respondent intentionally neglected his duty by failing to prevent the deceased, who is captured on CCTV footage, past him walking towards the swimming pool. That when it was established that the deceased was missing, the respondent failed to disclose to the school management and the parents that the deceased had walked past him towards the swimming pool. Preliminary investigations by the applicant have revealed that the deceased died of drowning, which is yet to be discovered whether it was caused by somebody or accidentally. The respondent has been interrogated and he has failed to disclose his place of abode, hence it will be very difficult to trace him in case investigations leads to his prosecution. The respondent, if released on bail, is likely to interfere with some witnesses who are yet to be traced and who are also the workmates. The life of the respondent is also in danger because the crowd outside there is angry on him as a result of the offense committed. Consequently, I swear this affidavit prior to have the respondent detained for 7 working days at Parklands Police Station in Nairobi.
Just for the record, Mr. Njiro,
yes,
you had indicated you were with Ms. the one dated 22nd of February 2022, seeking an order to issue against the respondent to continue to be held at Muthaiga Police Station for 4 days to enable the DCI to conclude investigations and have the respondent be arraigned in court for plea taking. The application was supported by the affidavit of number 67343, Koplo Bernard Gikandi, a police officer attached at the Directorate of Criminal Investigations Headquarters, Financial Investigations Unit. The grounds were that the DCI were investigating a case of conspiracy to commit a felony, obtaining money by false pretenses, stealing and money laundering involving over Kenya shillings 1 billion, stolen by the respondent and companies associated with him, allegedly stolen by the respondent and the companies associated with him. In addition, was that the respondent was aware of the ongoing investigations and impending arraignment in court over the said issues. The investigating officer further averred that on 21st of February 2024, the respondent was arrested at Jomo Kenyatta International Airport while on transit to Zambia out of this court's jurisdiction, and that he was a flight risk and he was likely to escape the jurisdiction of this court. He further indicated that the investigations were at an advanced stage and the respondent is likely to be charged in several cases involving over 50,000 victims spread all over the country. The deponent further indicated that the respondent was likely to interfere with the ongoing investigations, including contacting critical witnesses and concealing material documents necessary and relevant to the investigations. Upon cross-examination by Mr. Ndegwa Njiro, the deponent indicated the investigations commenced in the year 2019 and that the respondent was aware that he was being investigated, and so far he had not interfered with any investigations. He further clarified that the respondent was intercepted while going out of the country and there was no order stopping him from leaving the court jurisdiction. On cross-examination by Mr. Omari, Justice, he further submitted that the manifest submitted by the respondent's counsel could not be verified, and he urged the court to disregard the same. Mr. Mamboleo and Mr. Njiru, for the respondent, also urged the court to dismiss the application seeking to detain the accused for 4 days. Article 49, 1G and H provides as follows. At the first court appearance, to be charged or informed of the reason for the detention, continuing or to be released, and H, to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. Both parties herein agree that bail is a constitutional right, as stated under Article 49(1)H of the Constitution, while accepting that the text of Article 1F of the Constitution may, in certain circumstances and contexts, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application to have him so held. The prosecution or the state must satisfy a double test. As it was held in High Court Criminal Revision number 208 of 2020, in the case of Sudi Oscar Kipchumba versus Republic, through National Cohesion and Integration Commission, Professor Justice Joel Ngugi, then a High Court judge and now a Court of Appeal judge, held that for continued detention, the state must satisfy a double test. And I'll quote, number one, that is A, first, the state must persuade the court that it is acting in absolute good faith and the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. B, the state must demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial, that is, the rights of the arrested individual, the public interest, order and security, and the needs to preserve the integrity of the administration of justice and the interests of the victims of crime where appropriate. And by virtue of Article 21(1) and Article 259 of the Constitution, the court must act to aggrandize and not to diminish the personal liberties of arrested individuals in line with other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests without rectifying or essentializing any. End of quote. The Respondents' Counsel referred this court to the High Court Miscellaneous Application number 213 of 2020, Chris Philip Obure versus Republic, where Justice Wakiaga held, and I quote, the role of investigations lies with the executive, and unless specifically provided for in the Constitution and statute, the judiciary should play a minimal role in assisting with investigations. In addition, they relied on the High Court Criminal Application number 304 of 2016, that is Michael Rotich versus Republic, where Justice Kimaru, then High Court judge and now a Court of Appeal judge, held that the police have no authority in law to arrest and detain any person without sufficient grounds. Counsel further relied on the following cases: High Court Criminal Miscellaneous Appeal number 26 of 2018, that is Betty Jemutai Kimeiwa versus Republic, where Article 49, 1G and H was exhaustively explained and illustrated by Justice Mureithi. And in the High Court Criminal Case number 44 of 2015, Republic versus Gerald Mutuku Nyalita and Jacqueline Mwendeki Thome, where Justice Mureithi held that there were less restrictive means of ensuring protection of witnesses if there was a likelihood of interference. So, what is the standard of proof in order to satisfy the double test for the continued detention of the respondent? The standard of proof is on a balance of probability. The question here is whether the prosecution did, on a balance of probabilities, demonstrate compelling reasons to hold the respondent in custody for 4 days pending the arraignment in court. First, the state must persuade the court it was acting in absolute good faith. The IO, while being cross-examined, informed the court that the respondent knew there were investigations which were ongoing against him, and that he was arrested while trying to board a Kenya Airways flight number KQ706 from Nairobi to Lusaka, Zambia. He indicated that they had been conducting investigations which were at an advanced stage. Having observed the investigating officer being cross-examined by a battery of advocates, especially on that issue, I believe there was nothing peculiar in arresting the respondent at the airport. On the second issue, as to whether the state has demonstrated that the continued detention of the respondent is the least restrictive action while balancing the rights of the arrested individual, the public interest, order and security, and the need to preserve the integrity of the administration of justice and the interests of the victims of crime where appropriate, the investigating officer, while being cross-examined, informed the court that the respondent was likely to interfere with the witnesses. However, he was not able to demonstrate that to this court. As I come to my conclusion, the investigating officer indicated that there were over 50,000 victims in the matter, hence, and the delay in concluding investigations, the investigating officer indicated that there were over 50,000 victims in this matter, and that is why there was a delay in concluding investigations, taking into account a colossal amount of Kenya shillings 1 billion was involved. Taking into consideration the submissions before this court and the material placed before this court, it's the court's considered opinion that the application by the prosecution partly succeeds on public interests. Taking into account that the respondent was arrested on 21st of February 2023, investigations must have been ongoing. Therefore, the disposition of the application is as follows. 1, that the respondent will be held at Muthaiga Police Station for 1 day, and that is today. Since I've taken into consideration he was arrested on 21st. 2, that since the investigating officer indicated that the investigations were at an advanced stage, the respondent be availed on 26th of February 2024 for plea be availed on 26th of February 2024 before the plea taking court. Those are the orders of this court.
For today means that the orders will lapse today at 12 midnight.
What I've indicated is yes.
You know, with that clarification,
Yes.
what will happen tomorrow, and will it be a lawful incarceration? Because if the order speaks that it will be held for 1 day, what happens?
Investigating officer is supposed to bring him on Monday. That remains the same. So based on that section, the Saturday and Sunday is excluded. That's why we jump to Monday. Thank you very much.
You didn't get the orders?
Yes, the orders are still the same.
Yes, sir.
No variation.
Yes, sir.
Yes.
So what happens between tomorrow and Sunday?
Yes, that's why I've said my orders are the same. Just you'll have a look and at the court file. Just
I am a bit apprehensive,
yeah.
and allow me to address a legal issue. And say that the DPP shall not require the consent of any person or the authority for the commencement of criminal proceedings and the exercise of his or her power, and shall not be under the direction or control of any person or authority. I didn't hear you say that there shall be a mention on Sunday. So it's Monday. I heard you say that he shall be charged on Monday. And that's why I'm raising a constitutional issue, whether this court can direct the DPP. Because the constitution...
Yes, maybe I can cut you short. I think you also jumped the gun.
Yes, sir.
Because automatically, Monday there'll be a mention in this matter.
Let me just read what you told us
Yes.
previously. In verbatim.
Let's leave it at that.
You know,
We mentioned the matter on
wish
Monday.
that you read the orders so that everybody is clear on what will happen on Monday. In verbatim, as you read previously.
Okay. Just for avoidance of doubt, the respondent will be availed on 26th before the plea taking court. Plea taking court.
Before the plea.
Yes.
So
Not taking
before you.
plea. Not before me.
For what purpose?
For plea taking court.
For what purpose, you know?
For further directions.